and Matt are part of the Innovate 518 team. So we're just saying hello and thank you. One of the great things about being in the Capital Region is we have some great resources that are always available to our startups, our businesses, and our entrepreneurs. And one of them is with us today. Vic is the IP legal pro that we rely on a lot to look at different intellectual property issues. So I'm not going to speak a lot. I'll let Vic speak because he is the expert. So thank you, Vic. I'm introducing you, and you can start whenever you're ready.
Great. Thanks for having me, Bob, and Innovate 518. It's always great to talk to people about IP since that's what we do. And sometimes the questions make me think a little bit and bring me back to kind of the beginning. So I'm Vic Cardona. I'm with Heston Rothberg Farley Mesiti. We're an IP-only law firm, which means we do only patents, trademarks, copyrights, and things related to that, including litigation. We want to talk about intellectual property, IP today. What is it? Why do I care? What can it do for me? Things like that. So assuming I have the slides working here, I'm going to try to go to the next one. Okay. So these are the types of intellectual property. We're going to talk more about patents than the other three, but patents, trademark, copyrights, and trade secrets. We're going to go into detail on all of those. And from there, let's go right to, all right, this is an introduction of why do I care? These are some of the issues that we're going to try to cover in conjunction with each of these types of protection. So IP helps me to commercialize and compete with other businesses. It allows me to sell things exclusively. Sometimes it gives me a monopoly. Sometimes it lets me license my rights. So I have rights. I can make some money by letting somebody else practice my invention, reproduce my copyrighted item, things like that. Enforcement, it can enforce that monopoly, prevent somebody else from doing something. Sometimes a piece of IP will help me defend against somebody else, whether that's just the existence of the IP or something else. And it's property, like real estate or the iPhone in your pocket. Intellectual property is that. It's property, and it can be transferred, sold, and otherwise dealt with. We're going to start with copyrights. What is copyright? Typically, when we think of copyrights, we think of books, movies, sculptures, documents, things along those lines. But it can be more than that. It has to be an original work of authorship, which is fixed in a tangible medium of expression. And that's the statutory language. It's the expression that's protected, not the idea behind the expression. And we say an original work, we mean something that's new to me. It's not new to the world. So if Bob and I both go take a picture of the same flower, I go 5 minutes after him, we can both sell those photos. The fact that he did it beforehand is not so important in contrast to patents, which we'll talk about later. So how long is my protection and who owns it? Copyright gives you protection from 70 years after the death of an author, 95 years from publication, and that's for a work for hire. When we talk about anonymous works, you're talking about 120 years from publication. Who owns it? Who owns a copyrighted item, a work of authorship? From the time it's created, fixed in that tangible meaning of expression, usually the author owns it. There are times when an employer can own it. If I'm working within the scope of my employment when I create something, then that work can be owned by my employer. So for example, say I'm a software coder. My job is to create software. That the rights to that software will go to my employer, not necessarily to me. There are also works made for hire. Suppose I hire somebody on the outside, ask them to do something for me. Those works are only owned by the person paying for them in the event that it falls within certain categories. These include collective works, tests, movies, compilations, and some other less relevant categories. In that case, if someone is creating a copyrighted item for you, you need to make sure that you have some kind of an agreement in place before they create that they promise that they're going to assign their rights later. If they don't assign those rights to you, then the author is the person that's going to own that. And that obviously can create a lot of conflicts. What are these rights I'm talking about? Copyright's also often described as a bundle of rights. It can let you perform something, distribute copies, reproduce it, and prepare derivative works. That last one, prepare derivative works, would occur, suppose I make a movie, write a book, then I decide to make a sequel. I, being the owner of the original copyright, I can do that. If somebody else tries to do that, they're going to be infringing my copyright because they're going to be using my characters and taking other portions of my original work. You see that little C in a circle on a lot of things? That is claiming your rights in a copyright, and it's best practice to add that. Another good practice is to register your copyright. It's not necessary. Once you write something down, fix it in a tangible medium of expression, you have some protection. If you register with the Copyright Office, you're going to get yourself access to the federal courts and also provide statutory damages in the event that you can't prove damages from somebody infringing your copyright. All right, speaking of infringement, what is it? Infringement is copying. That's presumed if someone has access to your work and there's substantial similarity between the original work and the work that's alleged to be copied. Copying, infringing work. In the event that we can't prove access, sometimes substantial similarity, if it's blatant, can be enough to prove copying. All right, why do I care? Again, if I'm not making movies or writing books, why do I care about this? Anything's fixed and tangible meaning of expression like this, we can try to enforce a copyright. So we look at software code, owner's manuals, blueprints, internal documents. These are things that people in a business, somebody can leave and take it with them. They can take your documents with them. If you can prove later, because they had access and there was substantial similarity between the two works, that's copyright infringement, and we can prove that. A good example is software code. If someone copies your software, if they blatantly block copy it, you're going to have substantial similarity between the original work and the infringing work. However, if I'm a skilled copier coder and I look at your work, I take the ideas from it and I make my own work, there's no substantial similarity, now I don't have copyright infringement. So it's really the substantial similarity, which is the important part. And as far as business is concerned, there's different documents and things that someone could take with you that would make copyright important. Does anyone have questions on copyright before we move to trademarks? All right, I guess it's on to trademarks then. Here we go. What is a trademark? A trademark is basically an indication of source. It provides goodwill. It provides to a consumer, it provides them an indication of source so they know what they're getting. If I'm a brand owner, it helps me build up goodwill and value by giving consumers what they want. They see this mark over and over again. They get what they want. They get what they're bargaining for. And people are happy about that. It breeds trust. So it comes down to goodwill and trust in part of both the consumer and the brand owner. We have a couple examples of trademarks. Everybody knows what these are. Tesla. Everybody's seen that one? Got Starbucks and the newer one, though not so new anymore, Instagram on the bottom right. And so here's, trademarks can be strong or weak. They're associated with a particular good or service. That strength can determine whether or not it's easy to enforce a mark and also whether it's easy or hard to get it through the trademark office. On this page here, we have the use of the word Apple for various goods, and it kind of illustrates this point of strong and weak. If we look on the left, you can see the arbitrary coin use of the mark. The word Apple for a computer, it doesn't mean anything relative to a computer, doesn't describe the computer, so that's a strong mark. On the other end of the spectrum, you've got a generic mark. You've got the word Apple for an apple. It is what it is. We can't give that word to a particular Apple seller because we'd be taking that word out of the lexicon and giving it to one person. So a generic mark can't be registered. We can't enforce that. Between the arbitrary marks and the generic marks, we have other marks, suggestive marks and descriptive marks. A suggestive mark is one which suggests but doesn't describe something. An example here is Apple a Day vitamins. It may suggest health, apple a day to keeps the doctor away, suggests health, and that's something that's registrable. We have cran apple juice. The apple juice describes what's in there, and that is not registrable and not enforceable. Other examples, if you look at the word igloo for coolers, that suggests something could be cold. It suggests a particular aspect of the goods, but it does not describe them. So suggested marks are okay. Other examples of arbitrary coin marks. If we think of the words Xerox and Kodak, those marks have nothing to do with the underlying goods and services. So those are arbitrary coin, those are strong marks. Next page, we have some generic marks and some that are at risk of becoming generic. The word aspirin, we think of as aspirin, but in reality, that's a brand name in Europe. In the US, it becomes generic because the particular word became so associated with those goods that it was no longer enforceable as a trademark. We've got some marks down at the bottom of the page that are at risk of becoming generic. Scotch tape. People don't really say, get me some of that clear plastic tape. They may say, get me some Scotch tape. People just say, go Xerox that. And they might go make a copy. That one's less used with all the different copiers on the market now, I guess. Advil. A lot of times people say Advil. They don't say Advil brand ibuprofen. And similarly, nobody says, go do a Google brand search for that. They say, go Google that, right? So that's an example. People kind of get lazy, and that can be a problem for brands, and they have to try to make clear that this is their trademark. Another example is people will say, FedEx that for me. They don't say, could you go send that using a FedEx brand courier service? So those are some examples of marks that could become generic and what generic really means. All right, there's some other types of trademarks. So it doesn't just need to be a word. Here's some slogans we've all heard of. So easy a caveman can do it. All you need is $1 and a dream. Just do it. So these all provide a trademark value for the consumer and for the brands. How about sound? You know, sound can be a trademark. I'm going to try to play a couple sounds here. We'll see if this works. All right. We know what that is, NBC. How about I don't know if that's close enough. I don't know if everybody can hear that. It's close enough to the speaker to hear that. That was the MGM Lion. Here is
You've Got Mail.
That one's obvious. It's a little old. ESPN. All right. Another example of different kind of trademark are color marks. So we think of UPS brown, yellow for sticky notes. John Deere uses green and yellow. Fiberglass insulation, Owens Corning, pink. There's even a registered trademark for yellow for wiffle ball bats. Now for colors, you need secondary meaning. These are harder to register than word marks. So you need to prove to the trademark office that this particular color to the consumer has secondary meaning. So it's a little harder to get these marks, but they're pretty valuable once you get them. Trade dress. We've all seen the Coca-Cola bottle, right? We know when we look at those bottles, if that's Coca-Cola and not somebody else's soft drink. How about trade dress? So this is packaging. This is the look of packaging as a trademark. Here we have the word Crest used a bunch of different ways, but we don't think of toothpaste when we look at this, right? We look at the bottom one, we think of Coca-Cola. There's Camel cigarettes. In the middle there, we have American Express, Reese's peanut butter cups at the top. So it shows you that it's not just the word. There's colors and lettering and fonts that can provide trademark value. All right, so what's trademark infringement? How do we prove that? There has to be a likelihood of confusion for particular goods and services in order for there to be trademark infringement. Here's an example of Holiday Inn and Holiday Motel. this was trademark infringement. You can see the color is the same. You can see the word holiday is almost the same. So there'd be a likelihood of confusion between these two. How about here? We've got Starbucks versus Charbucks Blend. This was found to be infringement. I'm sorry, this was not found to be infringement. This was under dilution law, which is a subset of trademark law. But long and short of it was that Starbucks lost this one. Here's one that Starbucks is pursuing. Frappuccino, Starbucks Frappuccino versus Fredduccino. There's a New York cafe which came up with this word Fredduccino, and they were using it for their coffee drinks. The cafe has since changed its name, but at last look, Starbucks was still pursuing this suit against this company. All right, so that's trademark, and why does it matter to you? Goodwill. If someone looks at a mark, they can think of past products, good works, philanthropy maybe. It can help sell. And for a consumer, he knows what he's getting. It's an indication of origin, indication of source. If I'm an established company, I might look at trademark and say, this protects my good name. It lets others know where this came from. It can even help you protect your domain. If you have a registered trademark, you can keep others from registering a mark which is similar to yours, at least in most cases, in cases of bad faith. So someone can't go and deliberately misspell your mark or do something which is close to it without there being issues. What about if I'm a startup? What does trademark mean to me as a startup? First thing is I want to get this mark. I love this mark, but we need to be careful, right? Can I use this mark? Is anybody else using it? It's going to cause me trouble. A lot of times, a lot of startups go to a lot of work into picking a mark, or maybe they should go to more work for picking a mark. They become very attached to a mark. And sometimes we need to remember to just let things like that go, especially early in a company's life. We don't want to spend time and money on a trademark if we're going to have a problem with that mark, if there's a big company or somebody else which is using a similar mark for similar services. And sometimes a trademark is all we have, right? If you can't get a patent, you don't have copyright. Sometimes a trademark's all you have. So sometimes you see these T-shirts, they say Supreme or Life is Good or some other slogan. A lot of times those T-shirts are the same as any other T-shirt, but they may sell better. And it's really due to that trademark. And that's all those companies have is the mark, and it becomes very valuable. If we look at an industrial sense, let's suppose I'm a battery assembler. I'm importing batteries from China and packaging with solar panels or house backup or whatever I'm using them for. Me and my competitor, we're all importing the same batteries, right? But it's my service, it's my good work, it's all that I'm doing, which is going to separate me from my competitors. So my good name is all I have to go on. And in that case, a trademark can be very valuable. All right, before we move on to trade secrets, any questions on trademarks or copyrights? And we can do it again at the end. Okay. All right, trade secrets are exactly what they sound like. It's a secret that's used in a trade. It provides a competitive business advantage. It has increased economic value if it's kept, but it must be kept. You need to take reasonable steps and actions to maintain secrecy so you can enforce this on people that might try to steal it. The term of a trade secret can be indefinite. People think often of the Coca-Cola and Kentucky Fried Chicken recipes. Those have been a secret a long time, and they go to a lot of trouble to keep those as secrets. All right, but what good is it really? Why not just get a patent? Well, a patent has stronger protection, but it requires full disclosure. I got to give the store away to get my patent, and it's more expensive. Some things are just better kept as a secret. You have an unlimited time period. It is harder to enforce. The important thing is that sometimes you can cover non-patentable subject matter, non-copyrightable subject matter you can't protect through other means by keeping it a secret. like I said, you need to have a plan. You need to have a plan for keeping a secret. It needs to be in employment agreements. It can't just be, sometimes people say, oh, I'm keeping that as a trade secret. You're only keeping it as a trade secret if you're really working hard to make it a trade secret. And sometimes things are patentable, but they're just best kept as trade secrets. Processes are patentable, but if a process doesn't show up in the product, so I make a product, I sell it via a particular process. If somebody looking at that product can't tell what the process is, then maybe I'm better off not disclosing it to the patent office. If I can keep it a secret, maybe I can keep that a secret longer than the 20-year patent term that I might otherwise be entitled to. Again, trade secret can be secret. It can be cheaper, but you need a plan. Questions on trade secrets? All right, then we're going to move on to the main event here. We're going to talk about patents most of the rest of the time here. And what is a patent? What's it good for? At its core, a patent lets you prevent somebody else from doing something in exchange for full disclosure to the patent office. And there's some language regarding that. And what can we do? What's patentable? Something needs to be useful, new, and not obvious. And useful, new are exactly what they sound like. Useful is, it's useful. New is it has not been identically disclosed before. For something to be not obvious, it's whether or not someone skilled in a particular art, somebody knows about a particular field, would find something to be obvious based on what's come before. And there's some case law which determines what's obvious, but it's a little vaguer. But basically, if somebody's skilled, they looked at something that came before, would they be able to come up with a new thing? All right, what can be patented? Basically, widgets and ways of doing things. It's a little more complicated than that. Articles of manufacture, compositions of matter, and improvements. What can't be patented? Basically, things that occur in your head or in nature. So we have laws of nature, scientific principles, and then illegal devices and things people just don't want patented. All right, we've got a couple different kinds of patents. Utility patents are what we usually think about when we think about patent protection. Design patents cover ornamental aspects of otherwise functional devices. A good example is furniture. Sometimes we'll get a patent for the arm of a chair. We won't claim the whole chair, just the arm of that chair is what's new and what we're going to try to get protection on. You can get plant patent protection for new varieties of plants. It's a whole lot less common, but it does happen. We used to have a plant guy that got some patents on plants. This is an image of the front page of a utility patent. And you can see the patent number, the inventor, the title, and the abstract are on there. The abstract is basically a summary of the invention, and that's in the bottom right. How about design patents? What are they? We can get claims on them. The claim basically says, go look at the images. The drawings are what's important in design patents. The claim portions are the stuff in solid lines, whereas the unclaimed stuff is that in broken lines. If we look at this image, this is the image of a patent for a lacrosse stick, basically a lacrosse stick handle. You can see that the lacrosse stick head is in dotted lines, so that's not claimed in this patent. This is mostly, you can see there's a notch there for holding the stick, and that's what this patent is all about. But you can see one part is in solid lines, one part is in dotted lines. This is a utility patent claim for a photovoltaic device. Every word in this claim needs to read on something for it to violate a particular device. This, you can see it's some paragraphs. You have some numbered paragraphs after this. This is an independent claim. This is the one that's usually used for infringement purposes, there'll be some other number paragraphs. They'll say the photovoltaic apparatus of claim 1, wherein the, PV module has this shape or something along those lines. Another thing is, so people always talk about claims as being similar to the meets and bounds description on a real property deed. So on a real property deed, you'll say, it goes to the tree, it goes 100 yards to the stream, and it describes the property. That is how this language in a patent is described relative to an invention. This is the meets and bounds of the invention. All right, so what is an invention? An invention requires conception and reduction to practice. Conception is that spark of genius. Somebody comes up with something. Reducing it to practice is building something or just being able to describe how to make and use it to one of ordinary skill in the art. All you need for a patent application is to be able to do the latter thing, be able to describe it, how to make and use it for one of ordinary skill in the art. All right, who are the inventors? So the inventors on a patent is the guy who conceives something, and that person and other people that contribute to a claim of a patent application. So I showed you one claim, but there's going to be, in most patent applications, going to be 20 or so claims. Who's not an inventor? Somebody who just contributes obvious elements, somebody who just works at the direction of the inventors, evaluates it, somebody who doesn't really add to any of the claims of the patent are not inventors. All right, who owns it? Who owns a patent? The inventor owns the patent once he creates something. There are often employment agreements which require someone to transfer rights in their invention to an employer. But if there is not such an agreement, the inventor owns it and he keeps it. If an inventor creates something, he initially always owns it, but sometimes he is required by contract to transfer his rights to his employer. All right, what's a patent good for? What is it really? It's often described as a sword and a shield, or a sword or a shield. The sword it's an enforceable right to prevent somebody else from practicing your invention. It's a monopoly. You can prevent somebody else from doing something. It's a shield in that sometimes there's a strength in numbers. If I have a whole bunch of patents and my competitor has a whole bunch of patents in a particular field, sometimes it's just easier to cross-license instead of trying to sort the whole thing out. Instead of suing each other, the existence of the patents themselves can be a shield. A patent can also be a shield in the examination process. So if somebody is doing an examination and they come across my patent, that can sometimes prevent somebody from getting a patent that's too similar to it. All right, so I've got a patent. Now what? It's binary. It's either granted or it's not, right? The existence of a patent, it doesn't grant me markets. It doesn't give me business. It doesn't necessarily let me enforce everything I think is my invention. It gives me that monopoly. A question is, how strong is my patent? Is it a narrow patent? Is it a broad patent? If I have a broad claim in a new field, that's very valuable. If I have a narrow patent in an existing field, that can be a lot less valuable. Strength in numbers, I said before, if I've got a lot of patents in a particular field, that can be important. How about patents as a perceived worth? A company, when it has patents, the perceived worth of that company can be stronger. It's no longer just a collection of real estate. There's something to the company. The flip side of that is sometimes you can have a patent, but if it's not an institutional product, maybe we have a problem if the person that came up with that patent and that IP has left. If there's nobody left to exploit that particular technology, then maybe that patent isn't worth as much as we might think it is. All right, how can I make some money on this? If I have a patent, I can license it. I can license the exclusive rights to it. That can be something that is either exclusive, non-exclusive, can be geographically based. I can slice and dice my rights up a lot. Or I could just sell my patent entirely. I could sell my company with the IP attached. Or I could just do it all myself, set up a company, bootstrap it, and make my invention and sell it. All right, IP, why is it important? As we discussed, IP can be an indication of innovation. A company can have a whole bunch of patents, and that can show how innovative it might be. There was a question of whether those patents are strong or weak, but it's an indication of some kind of innovation, if something else. It's worth to the organization. Patents can provide a payoff to the risk associated with R&D. So I've got this research and development department. My patent is going to be my monopoly at the end of that R&D tunnel. This can provide different potential avenues to expand your business, right? So I have this new R&D, I come up with a new patent. Now I can go off in a new direction, maybe expand my business. All right. This is my favorite part. My chair example. I took this chair example from one of my partners, but this kind of helps me tie everything together. So I came up with this great idea for a rocking chair. The problem is that Bob already has a patent on a chair, and that's causing me some problems. So this is Bob's chair claim. So this covers a chair having a horizontal surface, a bunch of downwardly depending legs. So anybody that makes anything that reads on this claim infringes Bob's patent, which is a problem for me because for me to make my rocking chair, I need to also make his chair. So I need to come to some kind of agreement with Bob, or else I can't make my rocking chair myself. Putting that aside, I've come up with this rocking chair. I went to the patent office. I came up with this claim, and I got this claim through the patent office. Bob's chair patent was not enough to prevent me from getting my rocking chair patent because I have this great claim for rocking chair, and you can see that last paragraph is these rocking arms collecting the bottom legs of the chair. So I'm happy about this. I have my chair, my rocking chair patent, and I'm going to try to sell rights to this. I can still sell rights to this chair, but my problem is I can't make it myself because I can't make the rocking chair without making a chair. All right, that's my rocking chair claim. Here's a depiction of my rocking chair claims. You can see how it includes the chair and it includes the rocker at the bottom. So here's a depiction of the rocking chair and the chair. You can see the red circles together. So if you look on the left, you have the chair, you have the rocking part at the bottom. I can't make the chair on the right without also reproducing the thing on the left. So that's a problem for me. I can't make a rocking chair without some kind of deal with Bob, some kind of licensing deal, or maybe he'll sell me his whole patent. All right, so what's the takeaways from this rocking chair example? You've got a sword and a shield. The sword is Bob's patent and my patent. We can prevent other people from making, including Bob can prevent me from making my rocking chair because I have to reproduce his chair. It's a shield. Bob's shield wasn't good enough. When it went through the patent examination process, my patent still got through. But it could be that there was, a bunch of other chairs that did not get through because of Bob's patent. So I can't make a chair, as it says there, without infringing Bob's patent. So this brings us to strength of patents. Bob's chair patent is very strong because he can prevent others from making something broadly as a chair. My rocking chair patent is very narrow. I can only sell or enforce rights to this rocker at the bottom of the chair in conjunction with the chair itself. So that brings it to the end. I can only move forward with Bob's approval. There's a possibility that I could sell my rights to a rocking chair maker. Maybe Bob sells his rights too. But other than that, I'm kind of stuck. And that brings me to the end. That's the rocking chair takeaway slide that I just referred to. And I'm going to leave that up. But from there, I'd be happy to take any questions.
So Vic, I got a few texts, if I can share that to maybe start
the
conversation. Somebody asked, what's the biggest IP mistakes you see the most?
Biggest IP mistakes. I think it's a timing issue. A lot of times people just wait too long, and it's usually because you're working on other things or you don't have the money. If you can, you should try to think about IP early. There is what we call a provisional patent application, which is a little less expensive than a regular patent application in the event that you've got something that's patentable. It buys you a little bit of time. A lot of times if you talk to your attorney, they'll work with you and try to find the cheapest way they can to keep you going. Another thing I mentioned was the trademark thing. Don't get too attached. I mean, people tend to really, really like their marks, but sometimes if there's something similar, just let it go and start over. It's really not going to matter in the end. Once you get your goods or services associated with your mark, it's going to move forward anyway. You don't need the perfect mark.
Thanks, Vic. Another question that came in was, when's the best time to engage an IP lawyer? At what stage of their idea or invention?
Yeah, I mean, early, I guess, is kind of the bottom line. And always, before you disclose anything or talk to anybody, there is a 1-year grace period in the US for disclosure, but that is much weaker than it used to be. We used to have a first to invent system. Now it's a first inventor to file system, which means somebody else could claim that they invented something when they really didn't. And then you have to prove that they didn't. And if they're first on file, it's going to be easy for them to move forward. So I guess the answer to the question is early. Talk to somebody early, at least to get a general framework of what you think is important going forward.
Even with just sketches?
It depends. Yeah, I mean, it depends what sketches are. I mean, you could file a provisional patent application based on what you have. Sometimes you file a provisional patent application, a year goes by, and you haven't really disclosed anything, and nothing's really happened, and you can just add to that and refile it. Now you're losing that year of priority, but if nothing's happened during that year, maybe you're better off just refile it. Go the cheap route again, and reevaluate after another year.
Thank you, Vic. Any other questions?
Yeah, Bob, I'll chime in. Thanks so much, Vic. Mac Ratton here from UAlbany. Thanks again, always, for your willingness to share your information and knowledge. My question's more around shared IP. Those of us who work in the university system, and in my role in economic development, we're trying to, and we're bringing small startups in some instances to collaborate with us who have some of their own IP, but are looking to leverage some of the research strengths that we may have at UAlbany, or could be same situation with RPI, Union, any of the various schools and colleges. What is some of your advice for startups if they're entering into kind of a arrangement where they need to kind of see and share intellectual property, or looking for a research project where they need the expertise of some university or outside third-party researcher to come in and look at really a shared arrangement? Are there tricks, tips that you might have in that situation?
I think it's the same answer. It's just you have to think about it early. A lot of times the universities have specific requirements, and they're, a lot of it's, from what I've seen, is pretty set. Not that there's not any flexibility at all, but it's important to kind of set that up early, so that especially the startups know what they're getting into, because sometimes they'll later on think that they have rights to something they don't, or maybe they think they have exclusive rights. It's really make sure you know what you're getting into up front. And it's always people are naturally don't want to deal with this stuff. So they get excited, they want to move forward. But sometimes you just got to take a step back and do some kind of, whether it's a joint venture or just shared IP agreement, something which just kind of lays everything down.
Thank you. Appreciate it.
Matt P., you have any questions?
I had one, but I'm thinking of how to best phrase it.
You're among friends, Matt. Come on.
Right.
So going back to the chair example,
Yeah.
as something, as time progresses, can something that is not considered obvious then be considered obvious even though it was disclosed to the patent office?
So it's obvious at the time of the invention is the way that that's supposed to go. So if you could prove that when you invented it, this wouldn't have been obvious, even though people might think it's obvious now. At the time, nobody would have thought that. So that's an important distinction. A lot of times it's only the time frame has not much time has passed such that it doesn't matter that much, but that is the rule at the time of the invention. Does that answer your question?
Yes.
Thank you, Vic. Matt, Maria, you want to wrap this up?
Yeah, if anyone has any other questions or anything to add. We just want to thank Vic again and for all the great information, and we'll be posting this on our website and also on our social media and YouTube page.
Sounds great. Thank you very much for the chance to share some IP.
Great job, Vic. Thank you so much.
Thank you, Vic.
Thanks so much,
Thank you,
everyone.
Thank you, Vic.